Welcome back to Legalese 123, where we are covering cases across America. Hello and welcome back to Legalese 123. I'm your host, Missy K. I hope everybody is doing well on this lovely Monday, the 26th of January. That's right. We are almost done with January. Can you believe it? It's just flown by. Well, I hope everybody out there is safe and warm. I know that there was the big ice storm that went across the middle part of the United States up into the eastern seaboard. So it hit some of the 13 colonies. So I hope everybody is staying safe and warm. I know some people are without power. Make sure you check on your neighbors, especially the elderly. Make sure everybody is safe. So, unfortunately, there is no court today for the Brendan Banfield case. So, we have something else because there's always something else going on. What are we going to talk about today? Well, the House defendants in the Karen Reed case has filed a motion to dismiss her case, which is common. So, we have oh boy, how many pages is it? I don't know, but it's a lot. And so we're going to go ahead and we're going to go through it. Here it is. Here it is. So let's see what the defendants in the Karen Reed case. Remember, Karen Reed is suing Michael Proctor, former trooper Michael Proctor, Yuri Buchanan, Brian Tully, and then Brian Albert, Nicole Albert, Jennifer McCabe, Matthew McCabe, and Brian Higgins. She is suing the town of Canton and the Massachusetts State Police sort of separately. So let's get into it. We're not probably going to go over every little thing, but we're going to get to what's called the gist of it. All right. So I'm going to try to make it bigger for you to read along. So here we have, it says, the preponderance of the evidence shows that just after midnight on January 29th, 2022, plaintiff Karen Reed, Miss Reed, killed Boston police officer John O'Keefe when she hit him with her car while driving drunk after a night of a heavy drinking, causing him to fall and hit his head on the frozen ground. Well, unfortunately, that fact was never proven, right? She had 2 trials. She was acquitted on both of them. So... Well, the first one was a mistrial. The second one, she was acquitted. Within 3 days of Officer O'Keefe's death, Miss Reed was arrested. 6 months later, a Massachusetts grand jury indicted her for inter alia, murder and manslaughter. In 2024, the Commonwealth tried Miss Reed on those charges. There was a hung jury. The jury was deadlocked as to whether Miss Reed was guilty, and a mistrial was declared. The next year, the Commonwealth tried Miss Reed again. Miss Reed was acquitted of murder, manslaughter, and leaving the scene of an accident, but found guilty of operating a vehicle while intoxicated. Then on November 17th, 2025, Miss Reed filed the present complaint against, among others, defendants Brian Albert, Nicole Albert, Jennifer McCabe, Matthew McCabe, Brian Higgins, collectively as the Commonwealth witnesses or individually a Commonwealth witness, whose only alleged relevant misconduct was providing statements to the police on or around January 29th. Ironically, the complaint of statements, specifically that Officer O'Keefe did not ever enter the home of 34 Fairview, are identical to statements that Miss Reed herself made to police on January 29th. Miss Reed seeks to hold each Commonwealth witness civilly liable for her arrest, indictment, and prosecution under 5 counts. Conspiracy to deprive Miss Reed of her Fourth Amendment rights, 1983 conspiracy, violations of the Massachusetts civil rights, malicious prosecution, intentional infliction of emotional distress. Civil conspiracy. Miss Reed's complaint against each individual Commonwealth witness is intended to deflect from her own liability in a pending civil wrongful death filed by Officer O'Keefe's family and is a transparent act of revenge against these individuals simply for providing truthful information to the police back in early 2022. Moreover, the complaint is a work of conspiratorial fiction devoid of supporting evidence. conspiratorial conspiratorial fiction, because they wrote it again. Regardless, even putting aside the complaint's conspiratorial, conclusory, or speculative allegations, which are entitled to no difference on the motions to dismiss. Ms. Reed's claims against the fact witnesses are virtually unprecedented under both state and federal law and fail on several grounds. First, the complaint violates the Massachusetts anti-SLAPP suit because Ms. Reed seeks to hold each witness liable for the petitioning activity, namely speaking to the police on or around January 29th. Talking to the police is a core protected petitioning act safeguarded by the Massachusetts anti-SLAPP statute. Moreover, Ms. Reed cannot meet her burden under the anti-SLAPP statute that each Commonwealth witness statements to the police had no bias whatsoever in fact. Indeed, Ms. Reed cannot meet her burden because the evidence conclusively established that Officer O'Keefe did not enter 34 Fairview Road on January 29th. Now, unfortunately, there is no concrete evidence that he did or did not. We have witnesses saying that he didn't, but there have been no evidence, no DNA, no nothing collected that said that he was in the house or that he wasn't in the house. Indeed, the afternoon after Officer O'Keefe's body was discovered, Miss Reed told the police exactly that. She didn't see Officer O'Keefe enter the home. Furthermore, there is other substantial evidence validating the Commonwealth's witness statements to police and the arrest of Miss Reed, including third-party statements, Miss Reed's intoxication, and Miss Reed's own reported admissions that she hit Officer O'Keefe with her car. There is also uncontradicted physical evidence from Miss Reed's criminal trial that Officer O'Keefe never entered 34 Fairview. His phone's GPS data confirmed that Officer O'Keefe ceased moving at 12:32 a.m., just moments after Miss Reed left 34 Fairview. Indeed, Officer O'Keefe's phone stopped moving on the front lawn and was never unlocked again by Officer O'Keefe after that moment, with its battery temperature dropping significantly by 1 a.m., further confirming that the phone and Mr. O'Keefe remained outside. Beyond the anti-SLAPP statute, the allegations against each Commonwealth witnesses are almost 4 years old, dating back to late January 2022, when they spoke to the police and Miss Reed's February 1st, 2022 arrest. Yet Miss Reed's 1983 conspiracy, the MCRA, the IIED, and civil conspiracy claims all have 3-year statute of limitations that begin to run out the moment Miss Reed became aware of the injuries underlying those claims. Miss Reed's unfounded malicious prosecution theory does not alter the claims a curable date, since the allegations against the Commonwealth witnesses relate to Miss Reed's purported wrongful arrest. Under such circumstances, courts parse identical civil rights claims for purposes of analyzing a statute of limitations. Claims accrued in early February 2022, they are all time barred. Indeed, in the court filings from the summer of 2022 in her criminal case, referenced in the complaint, Ms. Reed argued that the same conspiratorial theories that she continues to repeat here well over 3 years later. Finally, all claims that the Commonwealth witnesses failed to satisfy even the generous pleading standard under Rule 12b-6. First, Ms. Reed fails to state a malicious prosecution claim because she cannot plausibly establish, 1, that the Commonwealth witnesses commenced or continued the criminal proceedings brought against her, 2, that her arrest, indictment, and prosecution lacked any requisite probable cause, and that 3, that the Commonwealth witnesses acted with any semblance of malice against her. Second, Ms. Reed's 1983 conspiracy claims fails because the allegations are insufficient to impute state action onto the Commonwealth witnesses. Third, Ms. Reed fails to adequately to set forth a common law conspiracy claim because her allegations rely entirely on conjecture, and more notably because she fails to set forth any allegation that the Commonwealth witnesses acted with knowledge that a wrongful act was being perpetrated. Fourth, the MCRA claims fails because the complaint lacks any claim that Miss Reed experienced any physical harm as a result of the Commonwealth's witnesses' conduct and otherwise fails to set forth that Miss Reed was ever threatened, intimidated, or coerced by them. And finally, Miss Reed fails to state a claim for the IIED because nothing in the complaint outlines conduct that any reasonable person would consider beyond all possibilities bounds of human decency. Okay. Make no mistake, on its face, this lawsuit is nothing more than an act of retribution against those who did nothing more than speak to police and testify against her at a criminal trial. The complaint violates the Commonwealth's witness statutory rights, contains time-barred claims, fails to meet any semblance of plausibility necessary to state valid claims, and should be dismissed. Any other result would set a dangerous precedent for aggrieved criminal defendants to use the civil courts as a mean to sue adverse witnesses in the future, potentially encouraging future witnesses not to provide information to police. Now, that is actually that actually is all correct, right? The claims are actually correct. Now, I don't know about the timeline, but the claims that if this were to go forward and their grounds aren't considered, that it could discourage future people from coming forward because they might be sued. Are there other things, though, that you can sue for? Yes. Let's continue. Factual background. On the evening of January 28th, 2022, Miss Reed and Officer O'Keefe, who had been dating for several years, spent time at a bar in Canton, Massachusetts, where they met the Commonwealth witnesses. Miss McCabe then invited Miss Reed and Officer O'Keefe to a gathering at 34 Fairview Road in Canton, which was the residence of Mr. and Mrs. Albert. Despite consuming several alcoholic drinks, they all did, Reed drove herself and Officer O'Keefe to 34 Fairview. Miss Reed did not enter the residence and instead left Officer O'Keefe at 34 Fairview alone. The next morning, Officer O'Keefe was found unresponsive on the front lawn of 34 Fairview. Miss Reed first discovered Officer O'Keefe almost immediately. I don't know why that's in quotation marks. After she returned to 34 Fairview following the search with Miss McCabe and a third party, Carrie Roberts, despite an ongoing snowstorm and it being dark outside. Soon after Miss Reed discovered O'Keefe's body in the darkness of a nor'easter, the Canton Police Department arrived at 34 Fairview. Police officers, ambulance personnel, and fire department arrived to assist. As part of the investigative efforts, Sergeant Michael Lenk interviewed Mr. Albert, Mr. McCabe, and Miss McCabe at 34 Fairview the same morning, at which point they informed him that Officer O'Keefe was invited but never entered 34 Fairview. Miss McCabe also informed Sergeant Lenk that Miss Reed admitted twice that morning that she may have hit Officer O'Keefe with her car after she attempted to drop him off. Later that day, the Massachusetts State Police seized Miss Reed's cell phone and car following an interview that Miss Reed gave to MSP. After the seizure, it was discovered that Miss Reed's car had a damaged taillight. Forensic analysis of the car also uncovered pieces of broken glass on Miss Reed's bumper, and that were at least partially consistent. I believe that was found not consistent. Broken pieces of Miss Reed's taillight were found at 34 Fairview near O'Keefe's body, as well as on O'Keefe's clothing. Okay. Now, we all know that they didn't have possession of O'Keefe's clothing for a very long time. It was actually several weeks before Trooper Proctor turned it into evidence. So I would say based on that, you can't use that because it was never really actually proven, tested. Anyways, on June 9th, a grand jury returned an indictment against Miss Reed, and she was ultimately charged with second-degree murder, manslaughter, and leaving the scene of the accident. Following her indictment, the Commonwealth publicly filed on Miss Reed's criminal docket in the Norfolk Superior Court a statement of the case, signed by District signed by District Attorney Michael Morrissey, setting forth a preliminary narrative of the allegations against Ms. Reed that justified her indictment. The Commonwealth confirmed Ms. Reed's story that she and Officer O'Keefe on the evening of the 28th of 2022 were drinking at the waterfall with certain of the Commonwealth witnesses before being invited to a gathering at 34 Fairview. The Commonwealth statement also confirmed that Ms. Reed found O'Keefe's body in an active nor'easter. We just went over all of that. Ms. McCabe informed law enforcement that while she invited Ms. Reed and Officer O'Keefe the night prior, the two never entered the home. Ms. McCabe observed Ms. Reed's vehicle outside 34 Fairview before the vehicle eventually pulled away. The next time Ms. McCabe heard from Ms. Reed was at 4:53 a.m. when Ms. Reed called Ms. McCabe in a distraught state looking for Officer O'Keefe. Ms. Reed then drove to Ms. McCabe's home where the two, along with a non-party, Carrie Roberts, began searching for Officer O'Keefe. According to the Commonwealth statement, Ms. McCabe informed law enforcement that during the drive, Ms. Reed said, "Could I have hit him? Did I hit him? Not that I hit him." The Commonwealth statement also summarized the witness statements of non-party Carrie Roberts, who stated that Ms. Reed called her immediately after calling Ms. McCabe and informed Ms. Roberts that John O'Keefe was missing. Ms. Reed further told Ms. Roberts before arriving at 34 Fairview, "John's dead. Carrie, I wonder if he's dead. It's snowing. He got hit by a plow." That she hit him, according to the Commonwealth statement, Ms. Reed also told Ms. Roberts that she was so intoxicated the night prior that she didn't remember going to 34 Fairview. I don't recall that coming out, but okay. The Commonwealth statement additionally details other witnesses' statements gathered by law enforcement following the discovery of O'Keefe, including those given by Mr. and Mrs. Albert, Mr. McCabe, and according to Ms. McCabe's initial report. Okay. Reed's trials, where do you know? After almost 4 years after John O'Keefe's death, November 17th, 2025, Ms. Reed filed the present complaint. In it, Ms. Reed asserts 5 causes of action. We already went over that. The primary theory underlining these claims is that the Commonwealth witnesses falsely told police or conspired to falsely tell police that John O'Keefe never entered 34 Fairview, which contributed to the Commonwealth's decision to arrest Ms. Reed. For each count, Ms. Reed seeks damages caused by her arrest, claiming a loss of employment, professorship, private health insurance, home, and reputation. She also seeks legal fees and costs. Ms. Reed asserts several other claims against police officer Michael Proctor. He's not a police officer anymore. Yuri Buchanan, Brian Tully, and he has threatened to sue Massachusetts State Police in the town of Canton. Threatened. Each Commonwealth witness individually brings a special motion to dismiss Ms. Reed's state claims under the Massachusetts Anti-Strategic Litigation Against Public Participation, the SLAP. All right. Talks about the anti-SLAP. If the moving party meets that burden as any claim, the second stage shifts to the opposing party. Under Bristol framework, Ms. Reed must show by a preponderance of the evidence that each individual Commonwealth witness petitioning activities were devoid of any reasonable factual support or any arguable basis in law and cause actual injury to her. While Ms. Reed's claims against each Commonwealth witness must be evaluated individually and independently under the anti-SLAP statute, as an initial matter, it is evident that she seeks to hold all the Commonwealth witnesses liable simply for talking to and answering questions from the police. The Commonwealth witnesses neither swore out a complaint against Ms. Reed nor initiated any police interaction. Instead, they were mere bystanders whom police questioned and who provided truthful answers. Nothing more. Further, Ms. Reed complained of injuries are limited to harm caused by her arrest, indictment, and prosecution. The only pleaded conduct by each Commonwealth witness relevant to this alleged injury is the fact that each gave information to the police, information that was used along with evidence from Ms. Reed herself and others to arrest Ms. Reed. Ms. Reed's speculative and defamatory suggestion that some of the Commonwealth witnesses are responsible for John O'Keefe's death A claim that Ms. Reed lacks any good faith basis or evidence to assert provides no basis for the state law cause of action. Now that Miss Reed was found not guilty at a second criminal trial, she seeks to hold civil liability private citizens who merely spoke to the police and were forced to testify at her trial. The complaint against the Commonwealth witnesses has no precedent in Massachusetts law. Indeed, Miss Reed's current attempt to punish financially those who spoke to the police and testified for the Commonwealth violates the core policy of the anti-SLAPP statute to prevent meritless suits to deter common citizens from exercising their political or legal rights or to punish them for doing so. It talks about Nicole Albert, malicious prosecutions. They're going to go through each one of these for each one of the defendants. So that's why this is going to be long. I want to see what I want to see what the family group text messages were. I think we only just got partial of those, and I'm wondering if when and if those will all come out, what exactly was said in each one of those, because we only just got bits and pieces. All right. At the end of the second criminal trial, it was unrebuted that the Google search oh boy, occurred at 6:24 a.m. Indeed, the evidence at trial revealed that any contention that the Google search at issue occurred at 2:27 was based on fundamentally erroneous reading of the information. Miss Reed did not rebut this evidence. It actually says rebut, not rebut. All right. Each one of these. Compounding the lack of relevance, the complaint conspicuously admits that Mr. Albert had any legal obligation to retain his phone or that Miss Reed had any legal right to access his phone. Oh, the preservation order was getting ready to take place. Fifth, Judge Canoni denied Miss Reed's motion for a subpoena to access Mr. Albert and Mr. Higgins' phone, finding that the defendant has not met her burden. The court is not satisfied that the requested phones contain information that is evidentiary and relevant, nor is the court satisfied that the application is made in good faith and is not intended as a general fishing expedition. The court noted that the single unanswered phone call from Miss McCabe to Albert shortly after John O'Keefe's body was discovered is insufficient to establish any meaningful connection between the Albert cell phone and the criminal case against Miss Reed. The court similarly found that later communications between Mr. Albert and Miss McCabe were not relevant to the question of whether Miss Reed was criminally liable for Officer O'Keefe's death. According to Miss Reed's superfluous allegation that Mr. Albert destroyed his personal phone had zero bearing on her claims against Mr. Albert and does not defeat Mr. Albert's showing that her claims are based solely on Mr. Albert's petitioning activity. All right, what about Mr. Higgins' phone? Miss Reed alleges that Mr. Higgins destroyed his personal phone. Well, he did. He stated he did. For the same reasons described above, including Miss Reed's motion for a subpoena of Mr. Higgins' cell phone was denied and found nothing to be more than a fishing expedition in October of 2022. This allegation is not related to any of the counts that Miss Reed asserts against Mr. Higgins. Therefore, the allegation does not prevent application of the anti-SLAPP law statute to the law counts against Mr. Higgins. Miss Reed cannot meet her burden of showing each Commonwealth witness had no factual or legal basis for petitioning activity. Because the Commonwealth witnesses met their burden that one or more of Miss Reed's claims are based solely on their respective petitioning activity under the Bristol framework, the burden shifts to Miss Reed to establish by a preponderance of the evidence that the Commonwealth witnesses' exercise of their petitioning rights was devoid of any reasonable factual support or any arguable basis in law. Here there is no doubt that Ms. Reed cannot meet this standard. Indeed, she cannot provide any genuine evidence even to dispute the factual basis for the Commonwealth witnesses' petitioning activity. Furthermore, Miss Reed complains that each Commonwealth witness told the police around January 29th that Officer O'Keefe did not enter the home. Each Commonwealth witness has submitted a supporting declaration attesting to the fact that they made those statements to the police and that those statements were truthful. Miss Reed cannot rebut that or show any pending activity was devoid of a factual basis because that is exactly what Reed told the police on January 29th. Just hours after O'Keefe died, Miss Reed briefly spoke to the police and told police that she did not see Officer O'Keefe enter the home at 34 Fairview. Miss Reed never changed her 29 statement to the police. She did not provide any further information to the police after that statement or testify at either criminal trial. Officer O'Keefe was missing one shoe. According to trial testimony, this missing shoe was located hours later under the snow next to the curb where Miss Reed dropped him off. Lieutenant Kevin O'Hara, with relevant testimony, Officer O'Keefe's shoe was full of snow. In addition to the shoe, found near pieces of broken taillight. O'Keefe's cell phone was found underneath his body. At the second trial, the Commonwealth presented GPS data that O'Keefe's phone that showed his cell phone ceased moving at approximately 12:32 at the same time where his body was found at 6 a.m. That's not true. They had a big, bubble of where he could be. Oh, Ian Whiffen. Further testimony revealed that Officer O'Keefe's phone was locked for a final time at 12:32. Miss Reed also claims that Miss McCabe falsely told the police that Miss Reed made inculpatory statements that morning. But again, Miss Reed cannot meet her burden that Miss McCabe's statements to the police, her petitioning activity, were devoid of any reasonable factual basis. On the contrary, the Commonwealth statements identifies that several other individuals heard Miss Reed making incriminating statements. According to the statement, Miss Carrie Roberts told police that around 5 a.m. on January 29th, prior to the discovery of John's body, Karen Reed told her, "John's dead, Carrie. I wonder if he's dead. It's snowing. He got hit by a plow." Miss Roberts also described Reed as hysterical at the time. Yeah. Oh, the 14-year-old niece making statements. Miss McLaughlin hits the docket. Okay. The case should be dismissed. On the motion to dismiss, the court must determine if the facts alleged plausible I can't read. Plausibility narrate a claim for relief. Factual allegations present a reasonable inference that the defendant is liable for the misconduct alleged. Overall, the complaint must provide sufficient factual allegations for the court to find the claim plausible on its face. A court may consider matters for public record. Besides dismissal under anti-SLAPP, Miss Reed's 1983 conspiracy, the MCRA and the IIED, and the common law civil conspiracy claims against the Commonwealth witnesses must be dismissed because they're all subject to a 3-year statute of limitations, and that has expired. Dun, dun, dun. Okay. Concerning here is the implication that the Commonwealth witnesses are to be associated with the indictment and prosecution of Miss Reed because they testified before the grand jury and her criminal trials, plus the FBI. It is undisputed that the statements given to the police in early 2022 regarding O'Keefe's presence at 34 are the same as those that the Commonwealth witnesses ultimately gave during Miss Reed's 2 trial. By failing to allege that the Commonwealth witnesses participated in the indictment or prosecution in any other manner, Miss Reed is essentially asking this court to infer that since the statements that caused Miss Reed's wrongful arrest were also elicited as a part of the evidence presented against her at trial, the Commonwealth witnesses also should be associated with Miss Reed's prosecution. Of course, the complaint fails to mention the Commonwealth's witnesses trial testimony explicitly because Miss Reed and her counsel are well aware it is black letter law that trial witnesses are entitled to absolute immunity from civil liability for statements given during the course of judicial proceedings. Now, that is factual here. Will that be taken into account? Miss Reed fails to establish that the Commonwealth witnesses commence or continue the criminal proceedings. An individual may be said to have instituted criminal proceedings against another if he caused those proceedings to be initiated. For malicious prosecution claim against the individuals not vested with charging decisions, a plaintiff must show that the defendant induced another person, say a police officer or prosecutor, to lodge formal criminal charges. Huh. Well, that seems very relevant in the Aiden Carney case, right? They kept telling them to do something against Aiden Carney. Aiden, you might take some notes and sue under this uh, criminal proceeding. All right. Where there is no allegation that the defendants did anything to further prosecution of the plaintiff, or that the state actor relied on information when deciding whether to submit a criminal complaint. Miss Reed fails to allege that the witnesses took an active role in her investigation or prosecution, and she does not assert that they induced or pressured law enforcement to arrest Reed in any way. The complaint alleges only that these individuals caused Miss Reed's wrongful indictment, arrest, and prosecution, falsely representing that O'Keefe never entered 34 Fairview, relocating O'Keefe's body, as to Mr. Albert and Miss Higgins destroying or discarding their phones. Indeed, removing the speculation that the defendant Proctor had a relationship with the Alberts through a purported relationship with non-parties, Julie or Kevin Albert. The only interactions the witnesses are accused of having with the investigation and prosecution are through their witness statements and trial testimony, such as wholly insufficient. Moreover, Miss Reed fails to state that the charges against her were made in reliance on the witnesses' statements. The complaint, as well as publicly available information, outlines a vast amount of other evidence used to charge Miss Reed. Miss Reed fails to establish an absence of probable cause. Any reasonable person would have suspected Miss Reed's culpability given the evidence that Miss Reed herself outlines in the complaint. For example, Miss Reed admits to being outside of the home in the area where John O'Keefe was found the morning of his death. It is undisputed that Miss Reed's taillight was cracked when John O'Keefe's body was discovered. Miss Reed admits to seeing John O'Keefe almost immediately the morning of the 29th, notwithstanding the darkness or nor'easter conditions, and that she had never been to the house until the night prior. And a secondary independent investigation was conducted prior to the probable cause determinations, undermining the theory that the fact development was entirely controlled by the defendants. Collectively, this evidence is sufficient for any reasonable person to find probable cause to arrest Miss Reed. The complaint is also intentionally omits critical facts that were available at the time Reed was arrested and prosecuted, which further supported the probable cause determinations. Malice is defined as any wrong or unjustifiable motive. A plaintiff must show that the defendants were attempting to achieve an unlawful end or lawful end through unlawful means, or intended to harass, vex, or annoy her. Thus, the malice analysis is largely duplicative of the probable cause analysis, for the same reasons why the malicious prosecution claims fails under the prior two elements. It fails to show the witnesses acted with malice. When the named defendant in a Section 1983 case is a private party, the plaintiff must show that the defendant's conduct can be classified as state action. If there is no state action, the plaintiff's claim fails. The bar for such a showing is quite high and cautioned only in rare circumstances that private parties can be viewed as state actors. Conspiracy is alleged between state actors and private parties. The relationship or nature of cooperation between the state and individual must be pled in some detail. Dispositively, the complaint fails to allege any coordination between the Commonwealth witnesses and the state actors. Even reading the allegations in the light most favorable to Miss Reed, it includes only accusations that the witnesses coordinated their efforts through text messages, phone calls among themselves, plus meetings. Remember the meeting where they went over the timeline? There is no allegation that any of them communicated with law enforcement outside the statements that they gave in late January and early February. I find that hard to believe, but all right. Indeed, the complaint does not allege that the witnesses spoke to law enforcement at all after making their witness statements. Thus, show me your phones. Let's see your basis for the court to infer any relationship between Proctor, Buchanan, Tully, and the witnesses, let alone a relationship pled in some detail that is sufficient to impute state action. The confusing proposition that Proctor, Buchanan, and Tully coordinated with the Alberts and McCabes through Proctor's sister Courtney, who communicated frequently with Julie, does not salvage the claim. For the court to impute state action against the assertion, it would need to find that an agreement between the Commonwealth witnesses and law enforcement was somehow established through the three levels of back-channel communications involving two individuals who Miss Reed does not allege participated in the conspiracy. All right, moving on. Plaintiff's common law civil conspiracy claims fails since the complaint does not state a claim for the underlying tort of malicious prosecution. To state a claim for civil conspiracy, a plaintiff must demonstrate that a combination of persons acted pursuant to an agreement to injure the plaintiff. The plaintiff is silent as to which civil conspiracy theory is being alleged. However, based on the nature of the allegations, it appears Ms. Reed seeks to proceed on a concerted action of civil conspiracy. Concerted action of civil conspiracy. All right, footnote 10. To the extent that Ms. Reed's conspiracy claims against the witnesses is premised exclusively on the theory that they conspired with law enforcement, as opposed to only conspiring among themselves, such claims should fail for the reasons outlined in the respect to the 1983 claim. Namely, that the complaint is devoid of allegations and that the witnesses ever came to an agreement with law enforcement to commit a wrongful act. It is going to be kind of hard to prove unless they have some communications between them. First, the accusation of the unnamed Commonwealth witnesses or group witnesses relocated Mr. O'Keefe's body is vague and speculative. Definitely is. Subject to characterizations and unsubstantiated conclusions are not sufficient. All right, if they don't have proof of that, I'm not sure how that's going to go forward. Simply put, Ms. Reed cannot support a legally recognized valid civil conspiracy cause of action with a concocted and baseless conspiracy theory. I kind of like the writing in this, but it's not snarky enough. Let's get snarkier. The complaint does not adequately plead that Ms. Reed has ever threatened, intimidated, or cursed any of the Commonwealth witnesses. The allegations are merely that the Commonwealth witnesses gave false testimony and altered or destroyed certain evidence. Even accepting these allegations are true, this court recently held that conducting a sham investigation of the actual perpetrator, coaching, coercing, or otherwise fabricating evidence against the plaintiff, or causing witnesses to give statements and or testimony that would result in misidentification, or by offering false statements and testimony, do not constitute threats, intimidation, or coercion. Wow. You're making a claim for Aiden Carney there, right? There. Interesting. Wow. Offering false statements and testimony do not constitute threats, intimidation, or coercion. Wow. Because in Aiden's case, they were conspiring, they were communicating with the district attorney, Morrissey, and other law enforcement agents, Tully, to do something, right? And even Proctor had got involved in that. Aiden, they might be making a case for you here. Miss Reed purports to have suffered severe emotional and physical distress from the Commonwealth's witnesses' representations to law enforcement and other acts. All right. We just see. Okay. For the foregoing reasons, the court should dismiss Ms. Reed's complaint against the witnesses and the Commonwealth witnesses, their attorneys' fees for filing these motions, and award any other relief that the court deems just and proper. Oh, well, that was short. Okay. Nice. That wasn't that long. All right. So that was very short. I did kind of skip over some stuff. The law, blah, blah, blah. So what I'm going to do is I'm going to post this filing on my Facebook page and on the X. If you want to go see it, just go to my, where is it? My hand went away to the Legalese 123 right there. I'm on Facebook and X, and you can read it for yourself. So up next, we also have Brian Tully's information with his internal investigation. We got that coming up next. So let me know in the comments, what do you think? Do you think that this is the anti-SLAPP motion is going to take place? Do you think that she just doesn't have the gist of her claims to state that this is going to go through? I think some of her claims will. I think some of them will go away. I don't think that she has the sufficient evidence to get some of these to go through. I think maybe some of them will be removed and they'll go through on some other things, but we'll see. So make sure you stay tuned and you like and subscribe if you want to hear more about this case or other cases that are pending out in the world. Thanks for watching. Thanks for watching Legalese 123. If you like what you saw, please like and subscribe for more content.